Week 2 and 3, we're going to be looking at the no-fault system, the purpose of fault-based systems, remedies, damages, the history of intentional torts, trespasses versus trespass on the case, volition and intent and capacity, mode of mistake and accidents, and the torts of battery and assault. So the no-fault system is a system whereby the injuries that are caused by a private citizen to another private citizen are the damages from those injuries are covered by a publicly funded or pooled resource. And in this case, you don't actually have to figure out who did damage. If someone's hurt, they get injured, or they get compensated. But we all have to pay to that pool, and we don't have to really determine liability. And the rationale for this is that accidents happen, and more times than not, it's an accident. It could happen to any of us. It's not a result of someone being, choosing to hurt someone else. So the pros of this is, of course, that it helps everyone, and from a social justice perspective and an economic perspective, everyone gets help. And you don't have to pay for an adversarial system where it's $70,000 for a 3-day trial. The cons, generally there's fixed amounts that people get compensated, so they may not get compensated completely. Yeah. And I guess it would ruin the monopoly of litigation that lawyers have. So, justifications for a fault-based system. There were two mentioned in class, the moralist and the instrumentalist. So the moralist is just concerned with the justice between the harmer and the harmed. Deterrence and loss shifting are not their concern. Then there's the instrumentalist perspective that is concerned not only with the relationship between the two parties, but the greater welfare of society. And these are some of their justifications for a fault-based system. Number one is compensation, so loss shifting from the defendant to the plaintiff, and loss spreading, of course, is spreading that loss between the people who are paying the insurance premiums. This is a concern for moralists as well as instrumentalists. Justice, vindication and appeasement to avoid vigilante justice. So the vindication aspect of this justification is weakened through loss spreading. So if you injure someone and your insurance company pays, then there could be an argument that the loss is shifted to the insurance company or all the people who pay premiums, and thus you are less vindicated. But there are arguments on the other side of this as well. Deterrence, this is purely an instrumentalist concern. So this has to do with the promotion of a safer society. Critics would say that criminal law and human nature are the only systems of deterrence we need, so we don't crash our car into other people because A, we don't want to hurt them because we're human, and B, if we do, we'll go to jail. But this is nonetheless an aspect of our tort law system. So there are specific deterrents that operate against individual defendants, general deterrents that operate against common attitudes and behavior, and market deterrents, which causes producers to inflate the price of their product in order to deal with the liability that may or may not ensue. And if it's a product that's causing a lot of liability, then they'll pass on that price to the consumer. Less products will be sold and there'll be less chance of injury. Other justifications, education, the publicity from the people being held liable, publicizes a general standard of conduct. There's the ombudsman justification, so having a fault-based system gives the little person a way to get at the state and the rich and the powerful. And this can be seen as a moralist point too. And lastly, the psychological justification. It's a non-violent way of receiving psychological vindication. Note there is pressure to increase the scope of tort law to increase corporate and government responsibility. So an additional side note justification. The remedies in tort law are judicial or extrajudicial. The judicial remedies there are 4. The first one, award of damages, and this is just the right to pursue the money from the person who has injured you. You may not get it back. An injunction, there are prohibitive and mandatory injunctions, and these are an order to do a certain thing if it's mandatory, or to not do a certain thing if it's prohibitive. And the penalty for not following your injunction is contempt of court and or imprisonment. It's worth noting this is an equitable remedy used in the common law when other remedies are inadequate, and it requires discretion. You can get damages and an injunction. Declaration, these are formal statements or decisions of the court. They are usually used to settle a dispute or an issue of legal rights. The declaration that the person is entitled to something, or that something is unlawful, that a particular statute is ultra vires, and these are granted in limited circumstances. And number 4, orders of specific action. So these direct the parties to restore a pre-existing condition, and this is instead of paying damages. So damages can be broken down into pecuniary or non-pecuniary damages. Pecuniary are monetary damages. They're calculated in dollars and cents. Non-pecuniary damages cannot be subject to exact calculations. So disfigurement, humiliation, loss of enjoyment of life. It can also be broken down into special versus general damages. So these are damages, the special ones cannot be exactly quantified. The general damage, special damages can be exactly quantified. General damages cannot be exactly quantified. Now, we can have general pecuniary damages, so these are monetary damages that cannot be exactly quantified. So loss of future income would be a general pecuniary damage. Now for special damages, the ones that can be exactly quantified, the plaintiff must prove these special damages. So 5 types of damages. Number 1, nominal. This is a token but not necessarily small damage awarded to vindicate the plaintiff's legal right. It's only awarded in torts that are actionable per se. So this means that they're actionable without proof of loss. So you don't have to prove you've lost something in order to get a nominal damage awarded. And these are derived from the writ of trespass. Compensatory damage looks backwards and intends to put the victim in the situation they would have enjoyed had the injury not occurred. It's the most common type of damage. And it can be pecuniary or non-pecuniary. To add to the non-pecuniary damage, it is difficult to calculate because there's no marketplace for happiness. So it's a bit of a philosophical exercise. Third, punitive damages. These are interesting. These are to deter future behavior of the individual and others, and the moral blameworthiness of the defendant does come into play. And what the court must decide is what is the lowest amount that the defendant must pay in order to serve the deterrent purpose if they choose that there should be punitive damages. So we note in the B versus B case, there was a consistent incest and rape, a specific incident of rape whenever the girl was 20 years old, and her father at trial was ordered to award damages of $100,000 in compensation for psychological trauma, $75,000 in aggravated damages because of the historical abuse, and also $50,000 in punitive damages. Now, he had been criminally sanctioned for some of his actions, but the court felt that it wasn't all of his actions, and so they did award more punitive damage on top of the criminal sanction. Had he been criminally sanctioned for all of his unlawful activity, then they would not have been able to award any more punitive damages. That would have been known as double jeopardy. Continuing on, Witten and Pilot, classic case of an insurance company not making good on a claim after a house burned down, even though their adjuster, an expert engineer, and the fire chief all recommended they pay. And the court decided that they should pay $1 million in punitive damages, thereby sending a very strong message to the insurance world that this type of behavior is not permitted. So in this case, they decided that punitive damage awards should be based on the minimum amount it takes to deter the activity. They're not limited to certain types of cases. However, they are for only serious types of misconduct, but not within a certain class of tort. And there should be no set ratio between compensatory and punitive damages. So you may get $2,000 in compensation, but they have to pay $500,000 in punitive damages, or vice versa. Disgorgement. Disgorgement is when the defendant receives a benefit or receives an advantage or a benefit from you, but you don't actually lose anything. So that is a wrongfully acquired benefit nonetheless, and so disgorgement damage would be for them to give that wrongly acquired wealth back to you in some form. This is different than unjust enrichment, where the defendant actually does receive something from the plaintiff and must give it back, and is also different than restitution, where the defendant must give back exactly what they received from the plaintiff, from the plaintiff. So disgorgement damages are not allowable in some torts. They are allowed in proprietary torts such as trespass to land, conversion, and passing off. Disgorgement is also available in non-proprietary torts such as breach of contract. And it's worth noting that the plaintiffs cannot receive both disgorgement damages and compensatory damages. They need to choose between receiving the damages that will put them back in the situation that they were in before, or receive the benefits that that the defendant has received from the wrongly acquired benefit. And I think this relates to if a company takes your money and then earns profits from it, you may be entitled to the money that was taken and those profits. Though if they took your money, then that would be unjust enrichment, not disgorgement. Anyway, I'll have to look into that. Aggravated damages, these are punitive damages are most often given in intentional torts as opposed to negligence or other type of torts, presumably because the person intended to do it. So obviously that behavior needs to be deterred, and if they did intend to do it, then there may be reason for aggravated damages, which are that the plaintiff suffered additional injuries to their feelings, and the actions of the defendant were highly offensive and particularly repugnant. So this is a form of compensatory damage, and we can note in the B versus B case, the woman did receive $75,000 in aggravated damages for the particularly gross behavior of the defendant and the historical nature of her abuse. So the $75,000 was to pay for her emotional trauma above and beyond what the $100,000 in compensation for psychological trauma gave. So yeah, additional damages awarded for additional injuries to dignity. So the history of intentional torts. After the Norman Conquest, when the conqueror sought to impose uniform laws in England, we're going way back here, so he put in a writ system where there was only certain actions you could bring against people in the court, and it had to follow one of the writs. And generally they were only violent, so as to keep the king's peace. So there had to be violence in order for you to get an action heard by the court. Though you didn't have to prove damage, you just had to prove one of the situations described in the writs. So there was growing access to the courts in the year 1200. So they expanded the writ system. No, they didn't. They didn't want to expand the writ system. And so what happened were the clerks in the Court of Chancery would allow people to falsify their writs and claim that violence had happened when it actually hadn't happened, in order to get their case heard by the court. So the cultural environment in which this was happening was a feudal society. The consequence emphasis was on interest in land. It was a relatively static economy. The realm subject to disorder, in which life could be both. So life was brutish and short, and there was a strong central government beginning to emerge.